basic findings of fact. November 10th, 2025, about 1:30 a.m. on Highway 285. Sergeant Young with the Park County Sheriff's Office was following a dark-colored truck northbound. Sergeant Young did testify that she is not a drug recognition expert, has not taken the advanced A-Ride class, that she is certified in SFSTs, which focus primarily on drinking and driving, that she did not have any specialized training in identifying driving under the influence of drugs or drug use or the effects of drugs on someone's physiology or motor skills. That during the SFSTs, Ms. Good performed such that one clue was noted on a walk and turn test, no clues on the HGN, nor any clues on the one-legged stand. Sergeant Young asked if she could search the truck at some point, and Ms. Good declined to allow a search of her boyfriend's truck, not wanting to be responsible for that decision. Ms. Young was then placed in custody, presented with the option to take a blood test for compliance with the express consent. Some evidence of potential contraband was found after the arrest in one of Ms. Good's pockets, and contraband meaning the white crystalline substance on some folded tinfoil the officer suspected was methamphetamine, but that substance was not tested on scene. So let's break it down. Reasonable suspicion for the stop existed. Yes, the officer indicating that she observed weaving on multiple occasions, sufficient to suspect a traffic violation. Was there reasonable suspicion to extend the stop into a DUID investigation? Borderline. The officer's testimony is, for the most part, credible, though it does appear that she had perhaps exaggerated some of Ms. Good's own statements, particularly recalling that Ms. Good had OD'd on fentanyl when that is not what Ms. Good had said, denying that the decision to arrest was in no way based on Ms. Good's declining the request to search the vehicle, but at the officer's vehicle, when she's talking with her fellow officer, she said she ran the RO, registered owner of the truck, and then it came up as some unusual owner, and then looked up a prior stop where something was found in the truck that was suspicious, leading the court to conclude that they being the officers, were hoping to access the truck to see if there was any additional criminality afoot. Based on the totality of the circumstances, where we have someone at 1:30 to 2 a.m. having crossed the fog line and center line multiple times. And let me back up. The officer's body cam video footage observed by the court shows that Ms. Good was responding coherently, did not appear unusually jittery or shaky or hyper or otherwise unusual in her demeanor. So based on the fact that the officer lacked any significant training in identifying the effects of drugs or the effects of drugs on a person's ability to drive, the fact that Ms. Good performed what I would say about as well as can be expected on any roadsides, one clue out of a potential 6 plus 8 plus, I think 6 on the one-legged stand. No additional tests were performed to identify whether Ms. Good was under the influence of drugs. The court does conclude that the officer lacked probable cause to arrest. Therefore, the results of any blood work or search are suppressed, or any statements subsequent to the arrest.
The sergeant looks up at the judge. She has already admitted on the stand that she isn't a drug recognition expert. She has already admitted she didn't know how long the drug in question stays in a person's system. Now the judge is speaking, walking through the driving, the roadside tests, the eyes, the mouth, and then 4 words land like a verdict before the verdict the officer lacked probable cause. The blood test is gone. The tin foil found in her pocket is gone. Every word said after the handcuffs went on is gone. Somewhere in that courtroom, Natalie Good is doing math on what fighting this cost her. The gavel hasn't fallen yet. By the end of this video, you'll know exactly how an officer's own testimony can unravel a case built on instinct. This is Park County, Colorado. Just after 1:30 in the morning on November 10th, 2025, Sergeant Mackenzie Young, then a patrol deputy pulled over a truck on Highway 285 for a missing license plate light. The driver was Natalie Good. An equipment stop became a full driving under the influence of drugs investigation, and Good was arrested and charged with DUID. Months later, defense attorney Mr. Toofer argued in a Park County suppression hearing that the stop, arrest, and search all violated her rights, with prosecutor Mr. Matthews representing the people and the case before the presiding judge. Good was driving her boyfriend's work truck that night for one reason. He had a flat tire outside Denver, and she was bringing him a jack. She wasn't drunk, and she wasn't using anything illegal. She was 2 years into recovery from a fentanyl addiction she hadn't chosen. She'd believed she was taking oxycodone. Managing that recovery with a prescribed medication, Suboxone, taking it exactly as directed and submitting to regular testing. None of that mattered once the cuffs went on. This fight cost her the better part of a year and thousands of dollars defending a night she did nothing wrong. Young built her case piece by piece.
So I initially saw the vehicle traveling northbound. It did not have any license plate lights, and the tail light was a string LED light to appear as a functional tail light. As I began following it, I saw multiple driving actions. So I saw the vehicle's driver's side tires cross over the double yellow median. That is the yellow line in the center of the road. I saw it come back over. I saw the passenger side tires cross over the white fog line, which is the white line on either side of the edge of the road. I saw it go back over the median again, come back over the fog line 2 more times. At one point, it met the dirt shoulder.
And what tests did you perform?
I performed horizontal gaze nystagmus, walk-in turn, and one lane.
And Sergeant Young, how many clues did you observe on the HGN?
0.
I'll come back to that. On the walk-in turn, what did you observe on the walk-in turn?
She stepped off line.
Just one time?
I don't recall.
Okay. And any clues on the one-leg stand?
No.
When you placed Ms. Good under arrest, did you find any substances on her?
Yes.
Okay, what did you find?
So she was wearing 2 pairs of bottoms, I suppose is the word. When I was doing my search to ensure that she didn't have any contraband on her, she's wearing, I believe, sweatpants on the outside and either shorts or another pair of sweatpants underneath. In those pockets, I located a folded up piece of tinfoil with a white crystal substance inside of it.
And did you invoke express consent?
Yes.
And what tests did you request Ms. Good perform?
I requested she take a blood test.
And why a blood test?
Because based on my observations and the roadside maneuvers, I did not believe that she had any alcohol in her system. If any, it was little, as I did not see the clues I would typically see when somebody's impaired by alcohol. So I requested that she take a blood test.
Sergeant Young, are you a drug recognition expert?
I am not.
That piece of tinfoil you found in Ms. Good's pocket, what was on that tinfoil?
So there was a white crystalline substance on the tinfoil.
And in your training and experience, what did you suspect that to be?
I believed it was methamphetamine.
And then when you asked Ms. Good whether she would take a blood draw, how did she answer?
She consented to a blood draw.
Did you ask her about the tinfoil, who that belonged to?
Yes, she stated that she cleans houses for her job, and that she, found the tinfoil on the ground and put it in her pocket.
No further questions.
She testified Good's truck crossed the center line, then the fog line several times, even catching the dirt shoulder, reasonable suspicion for a stop nobody disputed. But once she reached the window, she said Good's mouth looked dry and crusted, her pupils looked constricted, her eyelids looked heavy despite jittery energy.
What?
license plate light.
Yeah.
Yeah, so you're required to have one of those.
Okay.
Additionally, you didn't use your turn signal when merging at the top of Crow Hill, right there when I was behind you. When two lanes are going into one, you gotta use your turn signal.
Oh my gosh.
Okay. And then at the bottom in Bailey, you cross over the fog line a couple times.
What's the fog line?
The white line.
Oh, okay.
Yep. So those are the reasons for the stop. Do you have your license,
Yes, I
registration,
do.
proof of insurance? Is this your truck?
No, it's my boyfriend's. It's his work truck, and that's why I'm not used to driving it. He has a flat tire in Denver, right outside Denver right now, so I'm bringing him a jack.
Okay.
Here's my license. Let me pull up insurance real fast.
So I just want to stop here. When you were talking about observing dry mouth during your conversation with Ms. Good, is this the period when you observed that dry mouth? Is this the distance you were from her?
This is as close as I think I get during the initial contact, so probably.
Sounds good.
I have to ask him. I can try and call him and see if it's in the truck somewhere that I just don't know about.
Okay. Have you taken any drugs or alcohol today?
No, not at all.
Okay. Your eyes are telling me something very different. So I really want you to be honest with me
No,
because
for
this
sure.
is what I do for a living.
No, I
okay,
understand.
so recognize that.
Yes.
Your eyes are telling me something completely different.
Mm-hmm.
Okay, so be honest with me.
Yeah.
And I will work with you.
I understand.
Okay,
Yeah.
I'm as cool of a cop as I can be,
No, and I appreciate it.
and I have a lot
Mm-hmm.
lot of leniency.
Yeah.
Okay,
No, that's fine.
when is the last time that you've used?
I don't use. I have to submit drug testing because I'm on Subutex. But when he's called me, I drank like 2 Red Bulls and I'm a little jittery. So, but I have to submit drug testing. Like I don't.
Okay, and why do you have to submit to drug testing?
Young ran the 3 standardized field sobriety tests and said the results, combined with the driving, pointed to impairment. Then came the testimony that mattered most. Good had mentioned Suboxone and had described once nearly overdosing after believing she was taking oxycodone laced with fentanyl. Based on the totality of the circumstances, Young arrested her, searched her incident to arrest, and found a folded piece of tin foil with a white crystalline residue she believed, based on her training and experience, was methamphetamine. She invoked Colorado's express consent law and requested a blood draw. On paper, it read like a methodical, escalating investigation, but nobody in that courtroom seemed to register what Young admitted just minutes into her own testimony. Almost as an aside, she'd never been qualified as an expert witness in a drug DUI case and couldn't say with confidence how many of her prior investigations even involved drugs rather than alcohol. The most important credibility question in a drug recognition case had already been answered, quietly, before cross-examination began. Here's the standard underneath all of this. An arrest for driving under the influence of drugs requires probable cause, a reasonable belief, based on specific and articulable facts, that a crime occurred, lower than proof beyond a reasonable doubt, but not nothing. Colorado's express consent law only applies once an arrest is lawful. If the arrest itself lacked probable cause, the blood test and the search that followed are legally poisoned along with it. So this hearing was never really about the tin foil. It came down to one question: did a deputy with no formal drug recognition training have enough to pull Natalie Good out of that truck in handcuffs? Twofer started with her resume.
Good afternoon, Sergeant Young. I want to start today by discussing some of your experience. You testified on direct examination that you had done, what, a couple of dozen DUI investigations at that point?
Correct.
How many of those investigations involved driving under the influence of drugs versus driving under the influence of alcohol?
I don't recall the exact number.
Ballpark?
I couldn't tell you. I've been at 2 different agencies, so I don't recall the exact number.
Less than 5, more than 5,
More than 5.
less than 10?
Probably not less than 10, no.
Have you ever been qualified as an expert on a driving under the influence case involving drugs?
I don't recall.
You would agree your CV does not include anything about being qualified as an expert, is that right?
An expert in what?
An expert as an expert witness in a drug-related DUI case.
I don't believe there's anything on my CV that has to do with that.
Let's talk a bit more. I want to just dive in a little bit more on your experience. So you were a patrol deputy in Douglas County from June 2021 to December 2022. Is that correct?
Correct.
That's roughly 18 months. Is that right?
Correct.
And then after that, you went from being a patrol deputy to be a dispatcher. Is that correct?
Yes,
Fair to say that's not a common career path.
it was for me
Why?
because that was the decision that was made.
Why was that decision made?
Objection relevance, Your Honor.
Mr. Toffer, if you can throw some reasoning for relevance in.
Your Honor, this goes to her qualifications. I mean, I would argue, I think it's fair inference that that's a bit of a demotion, and I think being able to question her about her experience goes to her overall level of training, her overall credibility, as well as whether or not she's qualified to opine on some of the issues.
And Your Honor, I would ask the defense, just ask the witness, was she ever disciplined? Was the witness ever demoted?
I'm going to overrule the objection and let defense counsel pose the questions he would like.
Why was that and I don't want to put words in your mouth, why was that the decision that was made?
Because I was demoted at the time.
For what?
I was involved in an off-duty car crash.
Go on.
I was involved in an off-duty car crash, and I admitted that I had been drinking to my watch commander, and they launched an investigation a week after as they did nothing on scene.
And you were ultimately convicted of a DWI.
How many do-ID investigations had she actually run? She couldn't say precisely. Had she ever been qualified as an expert in a drug case? She didn't recall one. The advanced drug recognition course. She'd never taken it. Then he went to her own record. Why an 18-month patrol deputy had become a dispatcher. Over the prosecution's objection, she answered she'd been demoted after an off-duty crash where she admitted to drinking and was convicted of DUI herself. The officer building a drug case against Good had once needed an investigation to admit her own impairment. From there, the wall came down fast. 0 clues on the eye test.
3 standardized field sobriety tests. You stated that you observed 0 of 6 clues on the HGN test. Is that correct?
Correct.
The walk and turn test involves, and I don't need to get deep into the math, but involves 9 separate clues that you're looking for, or 8 separate clues that you're looking for. Is that right?
I believe so.
And it requires somebody to take a number of steps, turn around, take a number of steps back. Is that correct?
That's part of it.
So there are a lot of opportunities during the course of that for you to observe a clue. Is that right?
I believe there'd be 8 opportunities.
Well, 8 opportunities for each step. Is that fair to say?
Sure.
Okay. And you only observed a 1 clue during the walk and turn. Is that correct?
I don't recall. I know I noted stepped offline, but I don't know if it was multiple times, but typically when I notate clues, 1 clue, there's not 8 clues for one clue, if you understand what I'm saying. So
Sure.
I notated the clue that I observed. I don't know how many times that happened.
In your report, you didn't write anything along the lines of stepped off the line multiple times.
I did not write that in my report.
Okay. I mean, the fact that she had admitted to using Suboxone that morning was something that factored into your decision to arrest her, wasn't it?
Yes,
Despite the fact that you didn't know how long the effects of Suboxone lasts?
that's correct. Because based on the totality of the circumstances of what I was seeing, I believe that she was impaired.
Have you ever received any sort of Suboxone specific training as far as what to look for in a driving case, of how that might impact somebody's driving?
I'm not a DRE or a drug recognition expert, so I would not be privy to that information.
Okay, so the answer to that question is no.
Correct.
1 clue, not several, on the walk and turn. 0 on the 1 leg stand. No paraphernalia in the truck. No fumbled documents. No confusion. Then the Suboxone Young admitted she didn't know how long it stayed in someone's system and had told a fellow officer on body camera that she believed it was meant to be used and then stopped when daily maintenance is exactly how it's supposed to work.
at the time of this stop, you'd agree that you knew very little about Suboxone.
I would not agree with that.
What did you know about Suboxone at that point in time?
So I knew that it was used to treat addiction, and I knew that it was an opioid agonist.
What she had told you was that she had used Suboxone hours earlier, like 14 hours earlier, right?
She told me, I don't recall the exact time. I believe it was 10 to 11 o'clock.
Okay. And you wrote in your report to 10 to 11 o'clock. So that's what, 12 to 14 hours beforehand? Is that right?
I'm not in the capacity to do math right now. So my stop was at 1:30. She told me 10 to 11 that day.
Okay. But generally, when you're writing reports, you use the military time, the 24-hour time. Do you understand what I'm saying?
Yeah, I didn't understand the question.
Sure. When you're writing reports, you're using, a 24-hour time clock. For example, 10 p.m. would be 2,000 hours. Is that right?
2,200 hours,
Oh,
yes.
2,200 hours. My math is off too. And you would agree that you wrote in your report that she told you she had taken her Suboxone at 10 or 11 in the morning. Is that right?
Yes, that's,
Okay.
yep, what I wrote.
She told you that she took Suboxone every day. Is that right?
I don't recall.
Okay. I'm going to come back to this Suboxone issue in a bit, but for now, let's talk about these roadside maneuvers and the evidence that you had. So you hadn't observed any controlled substances in the car before requesting that she do roadsides, right?
I did not.
You didn't observe any paraphernalia in the car, is that right?
I did not.
She didn't make any statements acknowledging that she was in possession of a controlled substance, is that right?
That is correct.
You testified on direct that she had declined to let you search the car, is that right?
Correct.
And I mean, did that factor into your decision to require her to offer roadsides?
No.
Okay, because you're aware that somebody can turn down a request like that because they have the right to refuse a warrantless search in these circumstances. Is that right? Correct?
Correct.
Okay. The time of the stop, you didn't know how long Suboxone stayed in somebody's system, did you?
I did not.
Your belief about Suboxone is that you use it and then you get off it. Is that right?
I wouldn't say I believe that. I know that it's used to treat certain substance addiction.
Okay, well, there was a period of time where you were speaking with another officer in this case, is that correct?
Yes.
During that conversation, do you recall saying, because Suboxone, you're supposed to from my understanding, use it and then get off of it? Do you recall that?
I don't recall that.
Toofer played the body camera clip. In it, Good never says the word overdose. She says she once thought she was taking oxycodone and it was laced with fentanyl. Young had testified minutes earlier that Good told her she'd overdosed. The tape didn't back her up.
Because I'm on Subutex, so it's a bicycle health. Like 2 years ago, I found myself on the wrong end of a fentanyl addiction because I thought I was taking Oxy. And so coming off of that, it's just like a program that's nationwide, I guess. And they help people come off of it, basically.
So I want to highlight where Ms. Good was talking about why she is on Subutex. What she said, you testified on direct examination that she had told you that she had overdosed. Is that what you said?
Yes.
What she explained there was that she found herself on the long end of a fentanyl, the wrong end of a fentanyl addiction 2 years ago. Is that correct?
In that clip, yes.
She didn't say anything in that clip about overdosing, did she?
Not in that clip.
When did she tell you that she overdosed?
I don't know, but I believe at some point she stated that she had an overdose because she believed that she was on Oxy and it was a fentanyl.
Well, she had just said right there that she thought she was taking Oxy. Is that right?
Yes.
That discussion about an overdose, I mean, is that your assumption based upon her saying that she thought it was an Oxy and it was a fentanyl?
So you played 4 minutes of my initial interaction. I believe that there is more interaction with her specifically telling me that she had been taking Suboxone.
I just hit pause. We're going to get into it.
Okay, so yeah, I don't know what exactly she said during those interactions, but you're asking me about just 4 minutes, and obviously I can't tell you in that time frame.
Going to move forward. And you testified on direct examination about having a conversation with another officer. Is that right?
Correct.
And during that conversation, you discussed your observations and the evidence that you thought that you had of her being under the influence with that other officer. Is that right?
Correct.
Here is the moment that decided the hearing. Young admitted she'd looked up the truck's registered owner mid-stop, found a prior unrelated contact where contraband turned up, and told her partner she wondered if a drug recognition expert was still awake to come out. She was fishing for more before she ever had enough.
So, eyes, bloodshot, glassy. She said that she took some box. So, roadsides are bad, but based off driving actions and the eyes, I'm a little concerned. And then she pulled out of her pocket and she got out of the car a big ass torch. So,
I didn't see her eyes. Other stuff looked fine.
yeah.
See,
Yeah, I'm just concerned about
it's so lots of
it's what gets you off of opioids. So it's essentially like an opioid.
So what you told that other officer is it's essentially like an opioid. Is that right?
Yes.
Okay. And that's a little bit slightly different than what you testified to here today. Is that right?
Correct.
So your perception the night of the stop was that Suboxone was essentially like an opioid.
That is what I discussed with a partner.
Okay.
Based off the driving and everything else, I'm not comfortable letting her drive. Unless I don't know for sure, sir. I'm wondering if Tyler's still awake.
And since when you said I wonder if Tyler is still awake, would that refer by chance to Deputy Tyler Watson? And that's because you were considering reaching out to him, is that right?
I was considering reaching out to him as a DRE
Okay.
to come out and do a DRE evaluation.
Gotcha. You didn't do that though, did you?
I'm sorry?
You did not do that?
Freaking cold.
Reach out to him?
Yes.
Or I reached out to him. I did not make contact with him.
Okay, gotcha. But so you never made contact.
I did not make contact. I did reach out.
Okay.
And you know what's interesting? When I saw the RO of this car, I looked it up. Because I was like, is this a guy or a business? It comes back to Home Gun Clarence. Yeah. So look at this. Clarence Home Gun from Fairplay. It's the RO of this vehicle. It's her boyfriend. Look what they found in the car.
And when you're saying look what they found in the car, is that something from a previous stop?
Yes.
How long before you had interaction with Ms. Good was that previous stop?
I don't recall.
Okay.
It was while I was waiting to hear back from the several people I reached out to for DRE.
should be able to.
And she admitted to using Suboxone this morning.
Yeah.
I don't know how long that stays in your system for. I don't know. I don't think that she's okay to drive. Based off of what I'm seeing, the driving actions. She said that she's been on Suboxone for 2 years after she almost she almost died of fentanyl.
And again, that clip I played you earlier, you didn't say that she almost died of fentanyl in that, did she?
She built a drug case without knowing the drug. In the real world, that's the gap between a felony conviction and a case that never reaches a jury, because probable cause built on a misunderstanding of the very substance at issue doesn't hold up, and under the exclusionary rule, evidence downstream of an unlawful arrest can be erased entirely. A properly run investigation should have called in a certified drug recognition expert before arrest, not after, something Young herself considered and never followed through on. Prosecutors should have recognized, under the totality of the circumstances standard courts actually apply, that a case built on an uncertified officer's read of pupil size was fragile and insisted on toxicology or expert evaluation before filing. A properly prepared witness wouldn't testify to an overdose. The recording contradicts. Every failure landed on one person, a woman with no record who spent months, and thousands of dollars defending a case that never should have survived a hearing, and when an officer's testimony is shown to be exaggerated, there's usually no consequence beyond suppressed evidence, no discipline, just a quiet dismissal and the next stop. This is why the cross-examination worked the way it did. Probable cause requires specific, articulable facts, not a hunch, and by dismantling Young's training, her own history, and her exaggerations one at a time, the defense collapsed the totality of the circumstances the prosecution needed. That matters more here than at trial, because this hearing decided whether the evidence ever reaches a jury at all. Most people assume that once police start asking about medication or past drug use, an arrest is basically automatic. It isn't. The law requires the officer's belief to be reasonable and specific, not just confident. The prosecution's closing leaned on the driving itself, 6 or 7 line crossings near 2 in the morning, paired with physical signs Young called consistent with opioid use. Matthews argued a drug DUI simply doesn't look like an alcohol DUI, and that field sobriety tests weren't built to catch drug impairment the same way. The defense countered that stripped of the exaggerations, little remained coherent answers, clean documents, near flawless roadside performance, and a search that happened only after the arrest it was supposed to justify. Both sides left the same question sitting in front of the judge. When an officer's observations are honest, but her expertise to interpret them is in real doubt, how much weight should a hunch about the wrong drug actually carry?
Okay, let's go to argument. Mr. Toffer, whenever you're ready.
I think that the conversation, the debate between Sergeant Young and the other officer is notable. I think there's hesitation in there, and really what this is based upon is almost kind of a hunch and a gut feeling. I mean, when you look at the totality of the circumstances leading up to the arrest, there's just simply not probable cause to arrest her for a driving under the influence of drugs case. So really, the evidence that Sergeant Young is using to justify an arrest, using to justify the chemical test is observations of her eyes and observations of her driving over the course of 6 miles in an unfamiliar truck at 2 o'clock in the morning. Your Honor, she testified about the effects of meth. I'm going to ask the court to disregard that testimony because it was pretty clear from her other statements that she didn't actually believe that Miss Good was under the influence of meth. Probable cause is certainly a higher standard than reasonable suspicion. Contend that there just wasn't probable cause to arrest her for a drug-related driving offense. The chronology of this is also important. I mean, I've questioned her about, I didn't object to testimony about the search of her person. I discussed that in cross-examination because it's relevant to one of the issues in my motion, whether or not this was search incident to a valid arrest. My argument is that it wasn't a valid arrest, therefore the search should be suppressed. But that evidence that was found in that search cannot be considered when looking at probable cause to arrest her because that search clearly occurred after she was arrested. So for those reasons, Your Honor, we're asking the court to grant the motion to suppress.
Thank you, Mr. Toffer. Mr. Matthews?
Officer at 1:30 in the morning saw the defendant driving a vehicle without the proper equipment. Sergeant Young testified that she witnessed the defendant cross the double yellow line, the passenger side cross the white fog line, come back over the yellow line, cross over the fog line 2 more times, kick dirt up off the shoulder, cross over the double yellow line again, and then didn't use the turn signal when merging or turning. She said that the reason she believed the defendant to be impaired by drugs was the driving actions and the eyes. And the driving actions were weaving 6 or 7 times. That driving pattern is clearly significant. And this is a drug DUI, which is very distinct from an alcohol DUI. Field sobriety exercises are really meant to test impairment that alcohol would show. The indicators of impairment are just different with a drug.
The judge found reasonable suspicion for the stop clearly existed, but extending it into a full drug investigation was borderline, and on probable cause for the arrest went further still. Young's testimony was largely credible but exaggerated, her training was absent, and the body camera showed a coherent driver, not the jittery, confused one described on the stand. 1 clue out of 6, 0 out of 6, 0 out of 6. The court lacked probable cause to arrest. Every piece of evidence that followed was suppressed. This rests on one of the oldest protections in American law, the Fourth Amendment requirement that arrests rest on probable cause, not sincere instinct. The exclusionary rule and its extension, the fruit of the poisonous tree, exists so law enforcement can't shortcut that standard and keep the evidence anyway. It's the same principle behind Mapp v. Ohio, the Supreme Court case that first applied the exclusionary rule to state courts. What happened here is a small-town version of exactly what Mapp was decided to protect. Good intentions from an officer are not the same as legal authority. Probable cause protects every driver, guilty or innocent, from arrest on instinct alone. Natalie Good did everything right, and it still cost her months and thousands of dollars to prove she'd broken no law. The system worked here only because she had a lawyer willing to fight it line by line. For anyone who has handed a license to an officer with a flashlight in their face, this case is proof the burden of proof still has to mean something. Was what happened to Natalie Good one officer's honest, but untrained mistake or evidence of a system that lets officers escalate stops based on assumptions about drugs they don't understand, with no real consequence when they're wrong? And if it's the latter, what should actually change?